Hello, welcome back. This is Estates and Trusts Online Module 6C. We've been talking about changes after an estate plan is in place. And one of the things that can happen is beneficiaries can contribute to the demise of the decedent. So this module is very short, and it's about when we might want to prohibit a beneficiary from benefiting from the decedent's death. I don't know why I like this pig, sorry. Okay, so this is about pages 252 to 261 in your casebook. We've already talked about advancements in satisfaction, revocation by operation of law in a divorce, disclaimers. And after this module, you should be able to explain why a testator's beneficiaries have no incentive to eliminate the testator. Look for a state statute to specify when a beneficiary is barred from recovery. And given a scenario, explain whether a statute such as the one in the Swanson case would apply. Okay, so Swanson's estates. This is really a tragic story. I almost wish it weren't in the book. This was in Montana, and I suppose this probably made the national news, although I don't remember it. Jeanette Swanson shot and killed 2 of her 4 children to save them from evil, from something worse. She was mentally ill at the time. She knew what she was doing, but she thought she was doing a good thing. And the question is whether now she can inherit from their estates. And these were her 2 youngest. I think they were 14 and 10. The father says no. All right, so this is mother against father. Montana has a so-called slayer statute, which provides that an individual who feloniously and intentionally kills the decedent forfeits all benefits with respect to the decedent's estate, including an intestate share, if the decedent died intestate. The decedent's intestate estate then passes as if the killer disclaimed the killer's intestate share. Okay, and we know all about disclaimers now. Now, these kids did die intestate because they were kids. So the question is, was the crime or was the killing felonious and intentional? Now, we know that Jeanette did plead guilty. In fact, she called 911. She said, I did this. She told them why. And the court says that's really not the same as a guilty verdict. So the analysis really isn't quite as clear. And so we end up with this case being remanded so that a lower court can determine whether this was felonious and intentional. So here's, questions. What does it mean to be felonious? Is the killing automatically felonious if the killer is convicted of a felony? Even if the killer pleads guilty to a felony, does that necessarily make it felonious? Or conversely, could it be felonious if the killing is not a felony? So to be helpful, even though this court isn't going to make the decision about whether this was felonious, they do explain that felonious means wrongful, without legal excuse or justification. So we don't really need something to be labeled a felony under the state's criminal law. Okay, and the other thing that the court has to decide on remand is, in light of Jeanette's mental illness, was she capable of forming the requisite intent? So we'll figure out felonious and intentional, and if so, then we've satisfied the terms of that slayer's statute. There it is. That a decedent who feloniously and intentionally kills the decedent, or an individual who feloniously and intentionally kills the decedent, if that's what it was, then Jeanette has no right to inherit from the kids. And I'm guessing there must have been life insurance, or maybe they had some estates that were inherited. I don't know. At any rate, this story makes me very sad. So here instead is a beautiful picture of Montana. There we go. Now we can all be out there in the beautiful fields with the wildflowers. All right, told you this one was short. Thanks for watching, and I will see you in class.